Hello everyone, my name is Pawan and I welcome you all towards our YouTube channel Art of Law, and we have started with an initiative of training you all for the All India Bar examination. And today's class is very important because we'll be completing the Transfer of Property Act, the important sections you are supposed to know, plus what are the most repeated questions being asked for the exam. Everything one by one will be covering up. So before we start for today's class, I've just a small request, okay? Make sure that you have the Bar Act parallel with you. And along with that, when I'm explaining you, please do take down the notes, okay? Please do take down the notes. And along with that, all the Joby examples I'm giving it to you, you parallelly learn it, or else the entire process of me taking the class would be waste and it will not be going inside your head also. And I want to tell you one thing, even though Bar Act is there in your hand, irrespective if you do not know the entire concept of law very well, then what I'm going to explain you today, it's going to be really waste. Getting it? So keeping this in the mind, we'll be starting for today's class. We'll be covering about important repeated questions being asked again and again. So now starting with 2018 question, who is a garnishee? Okay, who is a garnishee? Four options have been given for the exam. One is about, so I just want to relate to you one more thing. If you learn AIB exam properly, the same exam ka syllabus you can also clear for All India, like even for civil judiciary exam, and even for the same fact law exams, many of the, for example, UPSC law optional ka exam, and along with that, even for LM entrance exam, CLAT PG exam also, it's like some kind of similar syllabus. It's very similar. So if you understand the concepts very well, you'll be able to answer the questions very well. Okay, now let's start. Who is a garnishee? Option A, third party who is instructed by way of legal notice to surrender money to settle a debt or a claim. Option A. Option B, a borrower arrested for defaulting. Option C, a person who cannot repay a bank loan. Option D, a person who mortgaged his farmland. Four options are given. So now who is this garnishee? Let me give you a very simple example, okay? That is about, for example, my name is Pawan and your name is Kavan. Just imagine my name is Pawan, your name is Kavan. Okay. Now what happened? I am basically taking money from Kamal around rupees 50,000. I'm taking how much money from Kamal? I'm taking rupees 50,000. Now I am the judgment debtor and you are known as judgment creditor. Very simple. Pawan is taking 50,000 from Kamal. Now Pawan is not paying back on the correct due date. Okay. Or Pawan is not paying itself. So what happened? Kamal is very smart. He approaches the court. Okay. He approaches the court and then he files the garnishee under Order 21 Rule 46 of the CPC. So what happens? The bank will act as a garnishee. Okay, the bank will act as a garnishee. He will completely freeze my entire bank account up to 50,000 ka cap limit, and then the bank will act as a third party and will pay the amount to the Kamal. Very simple concept. Getting it? So it's a very simple Order 21 Rule 46 of the CPC. Who is a garnishee? The third party who is instructed by a way of legal notice to surrender money to settle a debt or a claim. So very simple. So that is option A is the correct answer. I'm just repeating once again the option. The third party who is instructed by a way of legal notice to surrender money to settle a debt or a claim. So what happened? The third party is playing the role. Who is the third party over here? Is it the Pawan or is it the Kamal or is it the bank? It is the bank. So tomorrow for the exam also they can ask a reverse question. They can give a scenario to you. Okay, Mr. A versus Mr. B. Mr. A is owing rupees 50,000 to Mr. B, but he does not pay on correct time. So what concept will it be applied? Will it be garnishee? Will it be that? Will it be this? Will it be this? So you need to select option A as garnishee correctly. So I hope you understood 2018 ka important question garnishee very well. Okay, that's option A. Now, second question, doctrine of lis pendens. It's one of the beautiful concepts in TP Act. Very important, very, very, very important. So now, the doctrine of lis pendens is given under which section of the TP Act? Section 41, Section 52, Section 53, Section 53A. Okay. Now, what do you mean by lis pendens? I'll show you one thing. Okay. If you go to the Bar Act, if you go to Section 52, can you see lis pendens written over here? Obviously not. Section 51, can you see the lis pendens over here? Obviously not. Section 53A part performance, obviously not. There's no lis pendens. So, agar aapke exam mein, if you do not know the concept of lis pendens, having the entire Bar Act is really waste for you. Getting it? That's why majority of the students fail for the AIB exam or any kind of other law exams also, even though Bar Act is given to you. So, aapko basic concept, you should be knowing it. No kind of exemption is allowed for it. Now, let's start with what is this lis pendens ka concept? Okay, now lis pendens, what is it? If you observe here, it's called as pending. Okay, lis pendens is known as pending. It's like a pending dispute. It's called as lis pendens. Okay, very simple. Anything of pending dispute is known as lis pendens. So, for example, if there's a pending litigation to a case, okay, pending litigation to a particular case, can you proceed? For example, I'm Pavan, you are Kamal. Okay, there's a disputed land between Pavan as well as Kamal. So, what happened during this litigation process? Can I go sell this land to somebody else? Can I transfer the ownership to another person? Obviously not. I cannot do it. So, when there is a fight between me and Kamal over a piece of land, it is a lis pendens stage. It's a pending litigation case, a pending dispute case. Neither Pavan nor Kamal can sell this land to any other third person until there is strict order from the court of law. Very simple. That's called as lis pendens. So now we'll quickly go to a barrack. Okay, we'll open a barrack, section 52. You should be knowing barrack no matter what. No kind of exemption regarding it, because law students, we used to tell that the bread and butter of a law student is lying in the barrack. So आपको पूरा जानकारी of complete knowledge is required for you to know. So now if you observe over here, we will read section 52 now. Okay, the transfer of property pending suit related there too. So if you know lis pendens, you can understand that it's a pending suit. Very simple. I'll read the section now. During the pendency in any court having authority within the limits of India, excluding the states of Jammu and Kashmir. Now, Jammu and Kashmir has also been included after abrogation of Article 370, right? To establish beyond such limits by the central government of any suit or proceedings in which any right to immovable property is directly and specially in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceeding so as to affect the rights of any other party thereto under decree or order which may be made therein except under the authority of the court. So that means during the pending litigation stage, you cannot do anything with that respect to property. Very simple as that. Explanation, we'll just read the explanation. For the purpose of, so just make sure that you're writing the short notes in your barrack itself. So I'll tell you one thing, in your barrack itself, write down all the notes and keep it ready. So tomorrow if you're going for practice also, it'll be really helpful for you. So that's the reason I really hate people having this online copies with you. You should be having the soft copy, write it down. So even when you're arguing the case also, you can always refer to it. So your own handwriting, your own notes will be like very easy. So now I will quickly read across the explanation from my book. The explanation part, anyway, you can look at the soft copy which I'm sharing over here also. For the purpose of this section, the pendency of a suit or the proceeding shall be deemed to commence from the date of the presentation of the plaint or the institution of the proceedings in a court of competent jurisdiction, and to continue until the suit or proceeding has been disposed by a final decree or the order and complete satisfaction or discharge of such decree or order has been obtained or has become unobtainable by the reason of the expiration of any period of limitation prescribed for the execution thereupon by any law for the time being in force. So for the purpose this section, the pendency of a suit or proceeding shall be deemed to commence from the date of the presentation of the plaint. So from when the plaint is being issued or from the date when the institution of the proceedings of the court have been started, from that day onwards, we can consider what it is a pending litigation stage. Until it is completely disposed, can you do anything with respect to property? Obviously, you cannot be doing it. So very carefully, if you just try to read this particular section, you'll be able to understand it. Okay, I hope it's clear for you. Now, I want to tell you one more thing. If you learn section 52 alone, will it be enough? No. You should be knowing what is section 41, 53, 53A. Okay. Now, I'll go to now a very important section. Ostensible owner. Okay, section 41. Let's go to barrack 41 and let's read what is section 41. Okay, now yes, 41, 41, 41. Yes, ostensible owner. Okay, so I want you to read this parallel. I'll be reading it from my book. Okay, observe it. The transfer by ostensible owner, where with the consent express or implied of the person interested in immovable property, a person is the ostensible owner of such property and transfers the same for consideration. The transfer shall not be voidable on the ground that the transferor was not authorized to make it, provided that the transferee, after taking reasonable care to ascertain that the transferor had power to make the transfer, has acted in good faith. I'll repeat once again for your understanding. where the consent express or implied of the person interested in immovable property, a person is the ostensible owner of such property and transfer the same of a consideration. For example, Kamal is owner of a property. What? Kamal is owner of a property. So what happened? He transfers the on behalf, he makes me as an ostensible owner. That means that I can take all decisions on behalf of Kamal, okay, including developing the land or selling. Every decisions I can take on behalf of Kamal. Why? Because Kamal appointed me as an ostensible owner. That's what it's clearly mentioned. Where the consent express or implied, the person interested in immovable property, a person is the ostensible of such property and transfers the same for consideration. You're making me in terms of taking all kind of decisions parallelly for it. Either it could be consent with the element of express or implied mindset. Clear? The transfer shall not be voidable on the ground that the transferor was authorized to make it. So if I make any particular decision, that decision cannot be void. Why? Because I am an ostensible owner. Okay. Provided that the transferee, after taking the reasonable care of ascertaining that the transferor had the power to make the transfer, has acted in good faith. Okay, so that basically means that I have to act in good faith, and obviously that particular decision is valid. Very simple. Make sure that you're writing it down, this particular example, in your respective barrack, or else there's no point of me teaching it anything for today. All right, let's go to our next section, section 53. 53A is very important, very super important. Let's go with section 53. 53, it's like thoda simple hai, nothing much complicated. So if you observe fraudulent transfer, this is very simple, yeah. Any bacha can answer it. Section 53, fraudulent transfer. Every transfer of immovable property made with the intent to defeat or delay the credit of the transferor shall be voidable at the option of any creditor to defeat it or delay it. So if I'm making any transfer of an immovable property, okay, either to in a fraudulent manner or in order to defraud a particular person, which is out of good faith, then it is considered to be a fraudulent transfer. Very simple. So if I'm doing something out of good faith, under something in a fraudulent manner, I'm transferring my particular immovable property, then obviously under section 53, you can argue it. You can tell that your honorable court, my client has basically been affected by so and so particular person. He has been what invoked, like you can, as an advocate, you can invoke section 53. Say that there was any fraudulent transfer being invoked over here. Very simple. Let's start with section 53A, part performance. Very important. So in part performance, why you should be knowing it, I'll just tell it to you, because not only for your prelims exam, future if you're writing any kind of mains exam, that means written exam also, part performance in the TP Act is a very famous question. Okay, let's start with what is the part performance. Where any person contracts to transfer for the consideration of any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with a reasonable certainty. I'll repeat once again. Where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with a reasonable certainty, and the transferee has in part performance of the contract taken possession of the property or any part thereof, or transferee being already in possession continues in possession in part performance of the contract and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then notwithstanding that, or where there is an instrument of transfer that the transfer has not been completed in the manner prescribed thereof by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee, and person claiming under him any right in respect of the property of which the transferee has taken or constituted in possession other than a right expressly provided in terms of the contract, provided that nothing in the section shall affect the rights of the transferee. Now, let me quickly go to the section 53A, and I want you to quickly write down this particular example in your book. So this example is very simple. For example, if Pavan is selling his land to Kamal, okay? If Pavan is selling his land to Kamal, okay? Pavan is selling land to Kamal. So we both are coming to a consideration. Now what happened? Kamal pays the entire amount. Kamal pays the entire amount. But Pavan over here, he is not willing to perform, or he is not willing, he's refusing to sign the sale deed to everything. Okay, so if you observe, there's a part performance. Kamal has paid the full amount, but Pawan is not signing the sale deed. So there is a part performance being done. So when the part performance is being done, here the person, the buyer is basically being protected. For example, if you are a buyer, you being Kamal, you are basically being paid the entire amount. So you are being protected or bounded, completely being protected by the law. Getting it? So as you have been performed a performance as I have not been performed, I'll be punishable in front of the court of law. That's the reason very clearly, if you observe here, where any person contracts to transfer for consideration of any immovable property by writing signed by him or on behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has in part performance of the contract. That means that what, he has already partially performed the contract. Okay, taken possession of the property or any part thereof of the transferee, being already in possession, constitute in possession in part performance of the contract, and has done some act in furtherance of the contract. So if I've already done the part, performed that particular this one, and the transferee has performed or is willing to perform his part in the contract, then notwithstanding where there is an instrument of transfer, the transferor has not been completed. That means that you have done your particular duty. As a transferee, you have performed a respective duty. But as a transferor, I have not done my responsible duty in a prescribed manner. Okay. Then any person claiming under him shall be debarred from enforcing against the transferee or the person claiming under him any right in the respect of the property of which the transferee has taken or continued. That means that if I am not performing, then I'll be obviously being punished by the court of law. Very simple as that, because you've already been performed the part of the contract according to it. So later date, I cannot tell that just because Pawan refuses to sign this particular sale deed, there's complete kind of void. No, you can bring your part performance also in the court of law. Okay, very simple. So that is a one mere example. Okay, in many times when you purchase a particular land, this advance amount is basically being paid. So if you pay the advance amount regularly within that stipulated time, and you already sign in the respective contract that okay, I'm not going to sell to any particular person, as a seller, even though you pay the entire amount as an advance, I am not supposed to sell it to another person because there is already a part performance being done. Okay, I'm going very deep into it because many practical oriented questions can come from this particular section. Okay, now let's see about third question. What kind of property is transferable? Okay, what kind of property is transferable? So any kind of property, like for example, pension, public office, right to re-entry, it is literally not transferable. Okay, very simple. I think basic, any bacha can also understand. Pension, public office, right to re-entry cannot be transferable. But any kind of property, if not prohibited by law, it can be transferable. I've not written law here, but I'm just explaining to you. Any kind of property, if not prohibited by the law, then it can basically be in what? It can be transferable. Okay, so I hope these are basic things you should be knowing it. So just learn the difference between what can be transferred, what cannot be transferred. Fourth question. Okay, which of the following does not comes under the immovable property as per the TP Act? Okay, which of the following does not comes under immovable property as per the TP Act? So let's go quickly to the section 3. Okay, let's go to section 3. Let's section 3 definitions. Okay, so if you're a person who have not seen your barrack, then it'll be very tough for you. So just want to tell you. So now I want you to learn what is an immovable property and what is a movable property. If you know this both, then nothing to worry on. Okay. So today I'll be explaining you the difference between what is an immovable property and what is a movable property. But if you observe about movable property, there's no standard definition given in this particular act. So I'm going to explain to you a lot. Don't worry, in section 3, I won't go very deep, but certain things I'll be explaining to you in a very simple manner. Okay. So now I'll just read the first point over here. Immovable property does not include standing timber, growing crops, or grass instruments. So immovable property does not include. So what does immovable property? Immovable property. Movable property means what? Something which is moving. Immovable property means something which is not moving. So which is not moving is what? Write it down over there. Write it down. Stop this video. Pause the video and write it down. Land. I'm just dictating you this. Parallel, write it down. Land. Benefits arising out of the land. Okay. Land, comma, benefits arising out of the land, things attached to the earth permanently. Okay, so things attached to the earth permanently can be considered to be an immobile property. I'm just repeating once again. Land, benefits arising out of the land, things attached to the earth permanently. Example could be land, building, trees, rights. Rights ascertained with the land, minerals, water. So very simple. So either आपका land हो गया, आपका building हो गया, or आपका trees, or any kind of rights which is being ascertained by using the minerals or water of that particular lesson, then that can be considered as what? It can be considered as an immovable property. Now, what do you mean by this movable property? Just quickly write it down. Movable property can be like, as they have basically said, these many things are not including immovable property. That means that they can be the movable property: standing timber, growing crops, or grasses. So, for example, car, furniture, jewelry, agriculture produces share, bonds, and money. They're considered to be the movable property. So I hope by this definition you have full immunity to answer this particular question. Okay, which of the following does not comes under immovable property as per the TP Act? Sale, the sale of a ceiling fan, the right to claim maintenance, right related to lease, easementary rights. So now the sale of a ceiling fan is obviously not an immovable property. Okay, which of the following does not comes under the immovable property? Okay, so sale of a ceiling fan is basically a movable property. Okay, obviously it can be moved. Okay, whereas right to claim maintenance, right related to the lease, easementary rights. So everything, easementary rights, everything parallelly comes under what? It comes parallelly under the immovable property. Okay. Now, next important easementary rights. If you have a very simple question, I hope the other options are very easy for you. Easementary rights could be about, for example, Pavan. There's a Kamal's land over there. There's Pavan's land over here. But if Pavan wants to, for example, if Kamal and I have just imagine I want to cross a road, only then I have to get into my particular land. Okay, I have to cross a road, and that road is basically been attached to this Kamal's place. Okay, so I need to cross that particular road. So that road is considered to be this easementary rights. For me to use this particular road, only then I can access my house. So that comes under easementary rights. Don't worry, I'll explain in detail. But I hope this much is basically enough for you to understand. So learn section 3 properly. Learn the difference between movable and immovable property. Now, very important, yeah. The doctrine of liabilities was explained in the case of which case? Bellamy versus Sabine case. Which case? Bellamy versus Sabine case. What did they say? Liabilities. Very important concept is explained in Bellamy versus Sabine case. Now, let's quickly learn about the next important question. So, want to highlight this one more thing. This cases which not is given, just write it down somewhere. Okay. Major concept of list pendens. What do you mean by list pendens? I hope by now you know. Like half list pending, the pending litigation case. This major concept, important major discussion was happened in this particular landmark case of Bellamy versus Sabine case. Sixth question is about which of the following is not a vested interest. Which of the following is not a vested interest? Now, I'll tell you what you mean by vested interest as well as what do you mean by contingent interest. Very simple. Okay. So there's two difference I'm going to teach today. What is vested interest? What is a contingent interest? If you learn this, you can, very important question for any kind of competitive question, exams. This like these are two important sections. For example, here if you observe, just look into this diagram. Okay. A tells to B that, see, if you marry C, A tells to B that if you marry C, I will be giving you a land. Okay. A tells to B that if you marry C, I'll be giving you a piece of a land. That is called as contingent interest. You are fulfilling certain kind of conditions. For example, when you're small, your parents will tell you get good marks for this exam, I'll pakka buy and give you Milky Bar. I'll pakka buy and give you this chocolate bar. Okay. So that is called as contingent interest. You fulfill the condition, are beta, you will surely be getting it. That's called as contingent interest. Now, what do you mean by vested interest? Vested interest is nothing but on the happening of an event. For example, I say that Kamal, 10 years from now, okay, only after 10 years you will be having complete rights over that particular property. For example, if Kamal dies before that, okay, I'll be happy. If Kamal dies before that, his heirs will get the complete rights of that particular property. So only when happening of the respective, it's not a condition. Remember, it is a mandatory event over here. So there it is a condition. There it is a condition. Only if you marry, it is possible. So you have to fulfill the condition. But here it is not the condition. On the happening of the event, you will be getting it. So now, which of the following is vested and contingent interest? So both the options have to parallelly mention over. That's why I will just show it to you. Okay. So A stipulates that the title in a property shall pass to C on his death. Obviously, don't consider this. Don't even look into this particular option. It's invalid. A stipulates that the title in a property shall pass to C on his death of the B. No. A stipulates that the title in a property shall pass to C if he marries B. Contingent interest ka same example I gave it to you. Very simple. Okay. Now, A stipulates that the title in a property shall pass to C after 10 years. So here, what if you observe vested and contingent interest? What is it saying? Exactly after this particular happening of an event, you'll be getting it. So I hope you understood. As contingent interest means it's this option, vested interest means you can opt for this particular option. So now, very important aspects which I would like to explain to you today is about, let's go to a barrack. Okay, let's look into section 19 for you to understand what is a vested interest and contingent interest. Go to section 19, section 19, section 99, 19, 19, 19. Yeah. Okay, vested interest. Where one on a property, on a transfer of a property, and interest therein is creation in favor of a person without specifying the time when it is to take effect, or in terms specifying that it is to take effect forthwith or on the happening of an event. See, if you observe happening of an event, I give an example on happening of an event which must happen. Such interest is vested unless a contrary intention appears from the terms of the transfer. A vested interest is not defeated by the death of the transferee before he obtains the possession. Okay, very simple. Explanation are, an intention that an interest shall not be vested is not to be inferred merely from a provision whereby the enjoyment thereof is postponed, or whereby a prior interest in the same property is given or reserved or some other person, or thereby whereby income arising from the property is directed to the accumulated until the time of enjoyment arrives, or from the provision that if the particular event shall happen, so only on occurring of that particular event you will be getting all kind of benefits, but not before that. Only after the this particular year, this much only you will be getting it, then that is the scenario, that's it, you won't be happening beyond it. So now let's learn section 21, contingent interest, where on a transfer of property in interest therein is created in favor of a person to take effect only on the happening of specified uncertain event, only of happening of a certain uncertain event, for example marriage. You fulfill it, then you will be getting it, aram se. Or if a specified uncertain event shall not happen, such person whereby acquires a contingent interest in the property, such interest becomes a vested interest in the former case in the happening of the event in the latter. For example, I hope you understood, no? For example, हमारा contingent interest में you have to fulfill the condition, but when you're fulfilling that respective condition, then obviously from contingent to you are transferring to the vested interest. That's very clearly mentioned over here. I hope all these concepts are very easy for you. I hope I've just explained to you the maximum well simplified manner. Please do go through it again and again, only then it'll be going to your brain. We learned today garnishee, we learned about list pendens, we learned about TP Act, we learned about we learned about movable immobile property, we learned about the case name Bellamy was a Sapien case we learned, and then we learned about what is contingent, what is vested interest, section 19, section 21, section 3 we learned, and हमारा section 52 we learned fraudulent, sorry, section 53 fraudulent transfer, section 53A part performance, ostensible on a section 41 we learned, and immobile and movable property ka definition, both no matter what, until you're in the grave you should be knowing it. So that's all for today's video. If you do like this video, please do like, share, subscribe. Let me know what are your views about this respective video. If you want me to upload more kind of videos like this, let me know in the comments. And I think today's video, if you go through it, majority of the concept of specified TP Act is covered in detail and depth. I know it's been more than like in half an hour if I'm sitting in one stretch now, but I hope you all understood it. All the best. Take care.